Hey folks, I'm Professor Darius. Thank you for watching African Elements. In this episode, we look at the two cases currently in front of the Supreme Court and what it means for affirmative action. For a deeper dive, click the link above for a comprehensive collection of articles. Race-based affirmative action is a controversial topic. The United States introduced it in the 1960s to address discrimination based on race, gender, and other factors. Since then, there have been attempts to reshape it, redefine it, and even eliminate it. While some denounce affirmative action as reverse discrimination, others see it as a critical tool to ensure a diverse student body in higher education. Until now, affirmative action has survived court challenges, and as a result, universities and colleges across the country continue to use race-conscious admissions policies to promote minority representation in their student bodies. But what if that changes? What is affirmative action? Affirmative action is a policy or practice designed to achieve greater representation of ethnic minorities and women in the workplace, school, or other institutions. It's a controversial policy because it requires employers and educators and institutions to take race and gender into account in hiring and admissions policies. The controversy arises because the courts have been vague about how or to what extent to take race and gender into account, if at all. So, will affirmative action survive the current court challenge? On October 31st, the United States Supreme Court began hearing arguments in two separate lawsuits in which students for fair admissions challenged the admissions policies at Harvard University and the University of North Carolina. The cases could have wide-reaching implications for how universities of higher education might achieve racial diversity. The High Court agreed to review whether universities can use race as one factor among many in considering applications for admission. Doing so could upend decades of legal precedent. If the court strikes down affirmative action, it will likely mean that colleges and universities can no longer use race-conscious admissions practices. Supporters of affirmative action worry that the Supreme Court, which has been packed with 3 conservative justices over the past administration, could end affirmative action programs that have helped achieve student body diversity. Students for Fair Admissions brought the two cases challenging admissions policies at Harvard and the University of North Carolina. Initially, the Supreme Court consolidated them so that they could be heard together. However, during her Senate confirmation hearings, Justice Ketanji Brown Jackson testified that she would recuse herself from the Harvard case because she sat on the school's board of overseers. As a result, the court decoupled the cases, allowing all 9 justices to sit on the North Carolina dispute. Immediately following, 8 justices will hear arguments over the Harvard case. Students for Fair Admissions argues that considering underrepresented ethnic minorities as one factor for admission among others discriminates against Asian American applicants because Asian Americans are not included as an underrepresented group. A lower court ruled in favor of Harvard in 2017, saying that the school didn't engage in racial discrimination because the plaintiffs had failed to prove that race played a role in the admissions process. So, what is the current Supreme Court stance? The first legal challenge to affirmative action came with the Regents of the University of California versus Bakke in 1978. In this case, the Supreme Court ruled that the use of race as an exclusive basis for university admissions criteria, such as a quota system, violated the Equal Protection Clause of the 14th Amendment and Title VI of the Civil Rights Act of 1964. However, the court ruled that race can be used in university admissions decisions if there's a compelling state interest, as long as affirmative action programs are narrowly tailored to meet that interest. Adding to the complexity, 9 Supreme Court justices rendered 6 different opinions, including a strongly worded dissent from Justice Thurgood Marshall. Since then, U.S. courts have struggled to come up with a definition of exactly what narrowly tailored means. For example, in 2003, the Supreme Court ruled in favor of the University of Michigan in Grutter v. Bollinger, upholding the university's use of race in admissions. In a 5-4 ruling, the court ruled in favor of Michigan University's law school admissions program. The decision allowed universities to consider race among other factors in student admissions. In the court's opinion, The Equal Protection Clause does not prohibit the law school's narrowly tailored use of race in admissions decisions to further a compelling interest in obtaining the educational benefits that flow from a diverse student body. Consequently, the petitioner's statutory claims based on Title VI and 42 United States Code Section 1981 also fail. Also in 2003, however, the Supreme Court ruled against the University of Michigan in Gratz v. Bollinger, striking down the use of a point system awarded to ethnic minorities in undergraduate admissions. Later in 2016, Justice Anthony Kennedy wrote the majority opinion in Fisher v. the University of Texas, stating that race could be used as a factor in university admissions decisions, but it must be done in a fair manner. The ruling held that the University of Texas at Austin did not violate the strict scrutiny standard the court had applied in a previous ruling. So, as we can see, the term narrowly tailored is subject to wide interpretation. But what is the state interest, and why is affirmative action necessary to that interest? With American society becoming increasingly diverse, it's important for us to reflect that diversity in our institutions. Numerous studies have shown that diverse environments produce better educational outcomes. Evidence gathered by the Century Foundation suggests that racially integrated classrooms can reduce students' racial bias, improve satisfaction and intellectual self-confidence, and enhance leadership skills. These benefits may translate to better educational outcomes and, among other payoffs, prepare students to work in a diverse global economy, increasing the productivity, effectiveness, and creativity of the team. In 1996, California voters passed Proposition 209, banning consideration of race in college admissions. Since then, the state's UC system has acknowledged that despite its implementing race-neutral measures, such as eliminating standardized tests, it still struggles to bring minority representation to its student body. In a friend of the court brief, the UC told the Supreme Court that, despite its extensive efforts, UC struggles to enroll a student body that is sufficiently racially diverse to attain the educational benefits of diversity. The shortfall is especially apparent at UC's most selective campuses, where African American, Native American, and Latinx students are underrepresented and widely report struggling with feelings of racial isolation. In addition, race-conscious admissions policies are necessary to promote racial diversity in ways that a focus on socioeconomic status alone cannot. For example, admission based on socioeconomic status fails to take into account racial inequality. Students of color are more likely than white students to attend underfunded and highly segregated public schools. Black students also face suspension and expulsion disproportionately as compared to white students. It's on this basis that the Supreme Court's state interest doctrine rests. Affirmative action policies have been demonstrated to be in the state's interest as an essential tool to improve educational outcomes for all students. As it stands, it appears that the Supreme Court will render its decision in June of 2023. Given the conservative makeup of the court and its demonstrated disregard for precedent, it seems doubtful that affirmative action will survive this challenge in any meaningful way. Most likely, it'll be necessary to formulate alternative policies to ensure that the voices of underrepresented students and students of color are present within the walls of higher education. What are your thoughts on how we might address the state interest in diversity? Please join this critical conversation in the comments below. I'm Professor Darius, and if you're still watching, do consider joining the history makers in our Patreon community who make it possible for me to continue to make this content. As always, thank you so much for your support. If you'd like to become a history maker, you can join them for as little as $1 a month and get early access to ad-free videos. Or you can support us for free just by leaving a like, dropping a comment below, and subscribing. Either way, thank you for watching, and until next time, I'll see you in the comments.